everyone, welcome back to the channel EduTap. I am Arshdeep Kaur and I am back with another video on the Depositories Act. We have already done one video on this act and now this is the part 2 of Depositories Act 1996. As I've already told you that the SEBI Grade A Legal exam notification is out. So you have to start preparing for both the examination, the phase 1 and the phase 2 from now only. They are equally important. Please do not neglect phase 2 and do not think that you will prepare. You will start preparing for that after the phase 1 examination. Start preparing for the phase 2 examination from now only, right? So we are covering all the security laws. Security laws, as I've already mentioned, have been given 40% weightage. They are very important, right? I would like to tell you that EduTap is coming up with test series for both the phases 1 and phase 2 of this examination. It will include the chapter-wise tests, selection tests and full-length tests. So it's a great opportunity for you. Please avail it. Also, EduTap is coming up with live classes, live crash course on this examination, the SEBI Grade A Legal exam for both the phases, phase 1 and phase 2. It will include live classes, 60 plus live sessions will be included in this. The test series that I've told you about, it will be including that also, and it will include one-on-one mentorship. So to avail the offer, kindly check the link in the description below. So let's begin the lecture. Question number 1. Under what section of the Depositories Act 1996, SEBI has power to make regulation pertaining to the provisions of the Depositories Act 1996? SEBI has the power to make regulation under this act. So which section deals with it? Is the section number 25. Option C, section 25. Let's read the section. Without prejudice to the provisions contained in section 30 of the Securities and Exchange Board of India 1992, the board may, by notification in the official gazette, make regulations consistent with the provisions of this act and the rules made thereunder to carry out the purpose of this act. The regulations to carry out the purpose of this act, right? Who can do that? SEBI. Under what section? 25, right? So answer is option number C, that is section 25. Question number 2. In a bank, the transaction is done using a checkbook. Okay. What is used to do transaction in a demat account? As I have already mentioned, demat account is an account which holds shares and securities in an electronic format, right? So they are asking that what is used to do the transaction in a demat account? The answer is delivery instruction slip, right? You have to remember this one. Delivery instruction slip is used to do transactions in a demat account. Answer is option A. Transfers and transactions in a demat account are made through delivery instruction slip, DIS. Right? Now next question, question number 3. No depository shall act as a depository unless it obtains a certificate of commencement of business from the board. This certificate is given under which section of the Depository Act 1996? The answer is section 3. Section 3. Let's read it. Certificate of commencement of business by depositories. No depository shall act as a depository unless it obtains a certificate of commencement of business from the board. The board, the SEBI board. Unless it does not have this certificate, they cannot act as a depository. Subsection 2. A certificate granted under subsection 1 shall be in such form as may be specified by the regulations. Will be in such a form as has been prescribed by the regulation. Subsection 3. The board shall not grant its certificate under subsection 1 unless it is satisfied that the depository has adequate system and safeguards to prevent manipulation of records and the transactions. So unless and until the board is clear, the board is satisfied. So if the board is not satisfied, then they can hold on to that certificate, right? They cannot grant the certificate, provided that no certificate shall be refused under this section unless the depository concerned has been given a reasonable opportunity of being heard. But before refusing the request of the certificate, the depository has to be given a reasonable opportunity of being heard, right? So the answer was option B, section 3. Section 3 deals with the certificate of commencement of business by the depositories. We also get the answer to this question from this section. Who grants this certificate of commencement of business to depositories? It is the SEBI board. It is the SEBI, right? Question number 4. As per Section 4 of the Depositories Act 1996, a depository shall enter into an agreement with one or more participants as its. The answer is agent. Let's read Section 4. Agreement between depository and a participant. A depository shall enter into an agreement with one or more participants as its agent. So the depository participants are agents to the depository, right? Clear? A depository shall enter into an agreement with one or more participants as its agent. Second, every agreement under subsection 1 shall be in such form as may be prescribed by the bylaws. So the answer is agent. Question number 5. As per Section 11 of the Depositories Act 1996, register of beneficial owners shall be maintained by which of the following? So the registers of the beneficial owners will be maintained by who? It is the depository itself, right? Section 11. Register of the beneficial owner. Every depository shall maintain a register and an index. So they have to maintain a register and an index of the beneficial owner in the banner provided in section 150, 51 and 152 of the Companies Act 1956. Right? So who maintains such registers and index? It is the depository itself. Right? Question number 6. If a depository is required to enter into an agreement, fails to enter into such an agreement, such depository shall be liable to a penalty which shall. Don't go through these options, we'll straight away go to the penalty itself. Let's read the section. It is section 19B. Penalty for the failure to enter into an agreement. As I've told you in the previous lecture also, section 19A to 19G deals with the penalties in different circumstances. These have been given different circumstances and according to them the penalties have been prescribed. So one such penalty is 19B, penalty for the failure to enter into an agreement. If a depository or a participant or any issuer or its agent or any person who is registered as an intermediary under the provisions of section 12 of the Securities and Exchange Board of India and is required under this act or any rules or regulations made thereunder to enter into an agreement. If he fails to do so, then what will happen? Such person, whoever it may be, shall be liable to a penalty which shall not be less than 1 lakh rupees but which may extend to 1 lakh rupees for each day during which such failure continues, subject to a maximum of 1 crore rupees for every such failure. It will be minimum 1 lakh, then 1 lakh for each day till that failure continues, and the maximum will be 1 crore rupees for every such failure. So every such failure will have a different penalty. For every such failure is important here, right? So minimum 1 lakh, maximum 1 crore, 1 lakh per day for every such day that failure continues, right? Question number 7. What factors to be taken into account while adjudicating the quantum of penalty as per section 19I of the Depositories Act 1996? Now you must know that the quantum comes on later. That means he has been adjudicated as guilty, he has been declared guilty, he has been proven guilty, and now his quantum of penalty has to be decided. So during this, what all has to be considered, what all has to be kept in mind? The amount of loss caused to an investor or group of investors as a result of the default, the amount of disproportionate gain or unfair advantage wherever quantifiable made as a result of the default, the repetitive nature of the default. The answer is all of the above. All of these factors have to be taken account while adjudicating the quantum of penalty as per section 19I of this act. Let's read this section once. Section 19I, the factors that have to be taken into consideration. The amount of disproportionate gain or unfair advantage wherever quantifiable made as a result of the default. The amount of loss caused to an investor or group of investors as a result of the default, the repetitive nature of the default. So all of these have to be taken in account while deciding the quantum of penalty, right? Now we can move on to question number 8. Judges of a special court shall be appointed by which of the following as per section 22C of the Depositories Act 1996. So section 22C actually provides for the special courts for the speedy disposal of the cases, right? So they are asking that the judge of the special court shall be appointed by who? It is the central government, option B. Establishment of special courts is given under section 22C. The central government may, for the purpose of providing speedy trial of the offences under this act, may by notification establish or designate as many special courts as necessary. So as many special courts as necessary. A special court shall consist of a single judge. So a special court has how many judges? It will have a single one judge who shall be appointed by the central government. Who will appoint it? The central government, with the concurrence of the Chief Justice of the High Court. With the concurrence of the Chief Justice of High Court means with agreement with the Chief Justice of the High Court. Which High Court? Within whose jurisdiction the judge is to be appointed is working, right? So let's read it again. A special court shall consist of a single judge who shall be appointed by a central government with the concurrence of the Chief Justice of the High Court, within whose jurisdiction the judge to be appointed is working. Subsection 3. A person shall not be qualified for the appointment as a judge of a special court unless he is immediately before such appointment holding the office of a session judge or additional session judge as the case may be. So nothing less than session judge or additional session judge. He has to be at least an additional session judge or a session judge to be appointed as a special judge in this matter. So who is going to appoint the special judge? It is the central government, option B. Question number 9. Any person aggrieved by any decision or order of the SAT may file an appeal to the Supreme Court of India within how many days from the date of the communication of the decision or order of the Securities Appellate Tribunal to him on any question of law arising out of such order? The answer is 60 days, option D. Let's read the section 23F, appeal to the Supreme Court. So any person who is aggrieved by any order of the SAT, he has the right to move before the Supreme Court within 60 days from the communication of the order, right? Let's read it. Any person aggrieved by any decision or order of the Securities Appellate Tribunal may file an appeal to the Supreme Court within 60 days from the date of communication. Within 60 days from the date of the communication of the decision or the order of the Securities Appellate Tribunal to him on any question of law arising out of such order, provided that the Supreme Court may, if it is satisfied that the appellant was prevented by sufficient cause from filing the appeal within the said period, allow it to be filed within a further period of not exceeding 60 days. So the Supreme Court can again give 60 days period if the Supreme Court is satisfied that yes, they were prevented by a sufficient cause. That is why they could not file the appeal within the said period of 60 days. So again, 60 days could be given only if the Supreme Court is satisfied. The answer was option D, 60 days, right? Question number 10. Every proceeding before the Securities Appellate Tribunal shall be deemed to be dash and the Securities Appellate Tribunal shall be deemed to be dash. The answer is option D, judicial proceedings and civil court. Let's read the question again. Then it will be clear to you. Every proceeding before a Securities Appellate Tribunal shall be deemed to be a judicial proceeding and the Securities Appellate Tribunal shall be deemed to be a civil court. As per section 23B, subsection 3, every proceeding before the Securities Appellate Tribunal shall be deemed to be a judicial proceeding. So, every proceeding in SAT is deemed to be a judicial proceeding within the meaning of section 193 and 228 and for the purpose of section 196 of the Indian Penal Code, and the Securities Appellate Tribunal shall be deemed to be a civil court. SAT will be deemed to be a civil court, judicial proceedings and civil court, right? Now let's move on to question number 11. Special court shall be deemed to be dash and the person conducting prosecution before a special court shall be deemed to be what? The answer to this is option E. Special court will be deemed to be a court of session and the person conducting prosecution before the special court shall be deemed to be a public prosecutor. Don't get confused here. If it is the SAT, then it is a civil code. It is deemed to be a civil code. But if it is a special code, then it is deemed as a court of session, right? As we read earlier, that a special judge cannot be anything less than a session judge or an additional session judge. So in the same way, the special court is deemed to be a court of session, right? Answer is option E. Section 22F. Save as otherwise provided in this Act, the provisions of the Code of Criminal Procedure 1973 shall apply to the proceedings before the special court, and for the purpose of the said provision, the special court shall be deemed to be a court of session. And the person conducting prosecution before a Supreme Court shall be deemed to be a public prosecutor. So who is conducting the prosecution? He will be deemed to be a public prosecutor within the meaning of Clause U of Section 2 of the Criminal Procedure Code 1973. Subclause 2. The person conducting prosecution referred to in subsection 1 should have been in practice as an advocate for not less than 7 years. So he should have minimum 7 years experience as an advocate, or should have held a post for a period of not less than 7 years. Should have held a post for not less than 7 years in either the union or the state government, requiring special knowledge of law. Right? Let's read it. The person conducting prosecution referred to in subsection 1 should have been in practice as an advocate for not less than 7 years, or should have held a post for a period not less than 7 years under the union or the state, requiring special knowledge of law. Question number 12. Appeal against the order passed by the board or adjudicating officer for settlement of administrative and civil proceedings shall be made to. So appeal against an order of the board passed for the settlement. The appeal, where does this appeal lie? Appeal against the order passed by the board or the adjudicating officer for settlement of administrative and civil proceedings shall be made to. In this case, no appeal can be filed. Answer is option E. Where has it been written? Section 19IA, Clause 4. No appeal shall lie against any order passed by the board or the adjudicating officer for settlement of administrative and civil proceedings. So, no appeal can be filed. Question number 13. Any offence punishable under the Depositories Act 1996, not being an offence punishable with imprisonment or with imprisonment and also with fine, may be compounded by. So what is compounding? It is when the person in default pays the other party for the settlement, right? It can only be done when the offence is not punishable with imprisonment, either imprisonment alone or imprisonment plus fine, right? So when can this compounding be done? I have told you this. Now the question is that who can compound, right? So the answer to this is option E, A or C, which is Securities Appellate Tribunal or a court before which such proceedings are pending. They can compound such an offence which is not punishable with imprisonment alone or imprisonment plus fine, right? Let's read it. Section 22A. Notwithstanding anything contained in the Code of Criminal Procedure 1973, any offence punishable under this Act, not being an offence punishable with imprisonment only or with imprisonment and also with fine, may either before or after the institution of the proceedings. It can be before the institution of proceedings or after the institution of proceedings. Be compounded by the Securities Appellate Tribunal. So who can do it? Either SAT or a court before which such proceedings are pending. So the answer was option E, that is Securities Appellate Tribunal and a court before which such proceedings are pending. Question number 14. What is ISIN number? This is important. ISIN stands for International Securities Identification Number. So what does it stand for? It stands for International Securities Identification Number. It is a unique 12-digit number, right? It is a unique 12-digit alphanumeric identification number allotted for a security. So it stands for International Securities Identification Number. ISIN, International Securities Identification Number, is a unique 12-digit alphanumeric identification number allotted for a security. Last question, question number 15. Under Section 19G of the Depositories Act 1996, what penalty can be levied by the board for any contravention where no separate penalty has been provided under this act? So where no separate penalty, the penalties from 19(1). The penalties from 19A to 19G, where no such penalty has been provided, what will be the penalty in that case? It is option D. What will be the penalty in that case? Let's read it. Penalty for contravention where no penalty has been provided as per Section 19G. Whoever fails to comply with any provision of this act, the rules or the regulations or the bylaws made or the directions issued by the board thereunder, for which no separate penalty has been provided. So if anybody goes against any of these and where no other penalty, no specific penalty basically has been provided, then shall be liable to a penalty which shall not be less than 1 lakh rupees but which may extend to 1 crore rupees. So the minimum is 1 lakh and the maximum is 1 crore. It cannot be more than 1 crore, it cannot be less than 1 lakh. Right? In cases where no specific penalty from 19A to 19G have been provided. So the answer was option D. Option D was A and B only, that is at least 1 lakh and maximum 1 crore. This is the question for achievers. Which are the areas under which SEBI can make regulations as per the Depositories Act 1996? Format of records to be maintained, manner in which certificate shall be surrendered to the issuer, the eligibility criteria for admission of securities into the depository, the manner of creating a pledge or hypothecation in respect of security owned by beneficial owner, or all of the above. Please comment down the answer below. So that's all for today. I hope this was a helpful session for you. For more such videos, please subscribe to the channel EduTap. Thank you.